Okay, so good afternoon everyone and welcome to this Parker Bullen webinar. This webinar is on IR35, tax and worker status. I hope you're all well. So thank you for taking your time out of your busy day to join us. It's great to see so many of you. My name's Rachel and I'll be your host for this short webinar. So this is an informal chatty style webinar, so please do get involved. If you could place your questions in the Q&A box at the bottom of the screen, and we'll try and answer as many of them as possible, either during the webinar or after the presentation has ended. So this webinar is 20 minutes. It may run over slightly more to 30 minutes. We will be recording this webinar, so a link will be sent to you afterwards, and also a summary handout. So in today's webinar, we'll be talking about IR35, the tax avoidance legislation, with a specific focus on the importance of worker status. The presentators of today's webinar are Alana, who's a Chartered Legal Executive in the Employment Department, and Molly, who is a trainee solicitor in the Employment Department. The purpose of this webinar is for us to share with you some useful information, practical tips and guidance on the topic of IR35. Any advice we give is generic and should not be relied upon unless you have spoken to us separately and we've provided you with advice that is pertinent to your individual circumstances. I will now hand over to Molly and Alana.
Thanks, Rachel. So, as Rachel said, we're going to be looking at IR35, and our powerful question to you all to consider is, wouldn't it be great if you could be confident in your worker status and know that you're paying the correct tax for your circumstances?
So, before we look into the recent changes that have been announced in regards to IR35, it's important to understand what IR35 actually is. So if I just go through the slides. So what is IR35? So this was legislation that was introduced in the year 2000, which regulates tax and helps to stop tax avoidance. So who does it apply to? So the question here is it's where people are either genuine contractors or whether they are employees who are actually in disguising themselves as contractors. So how does this work? So the way that people do it is the workers will utilize the tax benefits of an intermediary. So for example, they will invoice their services through a limited company rather than do it as an employee. So why is this relevant? Why is it important? So as workers, you're able to be compensated by other means. So as someone who is self-employed, is a lot more tax efficient than actually being an employee. So it's mutually beneficial, because for the end client, if someone is a contractor, the client actually doesn't have to pay their own tax because that contractor is liable, and which is even more important for the employer. The client can avoid liability for any employment rights, so any unfair dismissal or wrongful dismissal claims. In addition, they don't have to provide them with the sick payments or holiday entitlements as you would as a genuine employee. So who does it apply to? Well, whether IR35 applies depends on the employment status of that individual.
And that's what we're really going to focus on today is really that worker status. So what's changing within the rules is that at the moment, the responsibility for determining somebody's worker status falls on that individual. But from April, it's going to be changing so that the business, so the end user client, or the company that the worker is providing services to, will then become responsible for determining their status. And also that the test is going to be slightly stricter, and that they'll be really looking at the reality of the situation, and it won't be good enough to simply call yourself a worker if you are clearly acting as an employee. And once that's been determined, the liability for actually paying the tax itself could shift from the individual over to the business if they are clearly an employee who's just sort of abusing the regulations.
So the key question is the individual a genuine worker or actually an employee in disguise? And that's what we're now going to explore. So,
sorry, go on.
So to determine this, we're going to look at worker status, whether someone's an employee or a worker. So there's 5 key factors that we're going to consider, which is control, whether the provisions of someone working for others, the tools and the branding that that individual uses, the idea of personal service, and mutuality of obligation.
So these are the tests that the tribunals also use, and they've been developed over decades of looking at. Usually it's used to determine whether the liability exists, whether that employer business is, should be paying compensation where there's a claim. Now, HMRC are going to use these same rules and same tests, and the reality is it doesn't matter what you call it, or even if it actually exists. There doesn't have to be a piece of paper or a contract. It's just looking at what the relationship actually is and using the theory that obviously actions speak louder than words. So we look at, if there is a contract, do the words represent the legal obligations of the parties, and do they represent the view that those parties had at the outset of the relationship? And also, how was the arrangement terminable? Because that will depend on the sort of weight that each party has on the contract and the power that sort of transfers between the two.
So now we're going to look at each of these 5 criteria that we've talked about and how an employer should determine the worker status of their individuals. So the idea of control over work stems from case law, and the principle is the quote to consider is the power of deciding the thing to be done, the way and the means of doing that thing, and that is what determines control. So we've just got a few questions that we're going to talk through that will hopefully make you think about what it means to have control of your work. So the first question is how do you do your work? How do you decide what tasks you will take on? How do you decide which tasks take priority? When do you do your work? Do you have set hours or set schedule? If your hours are controlled, so for example, if you have contracted hours of 9 to 5:30, and within those hours, your boss gives you work, and so my boss says, okay, well, here's a client, Molly, you need to act for this client. Or is it that you're able to choose with your work? So if I was able to choose my clients and choose whether I took on the work, then that would be more indicative of a worker rather than an employee. The second point is your work monitored? So as a trainee solicitor, for example, my work is closely monitored by my supervisors. It's reviewed by my supervisors, and I will have regular appraisals to see how I'm doing with my work. However, if I was a worker, that wouldn't necessarily be the case. It wouldn't need to be reviewed by anyone else, because ultimately, which is sort of the next point, that the liability falls with that individual. So another point is, do you need to comply with policies and procedures? So as employees, we have to comply with various procedures in regards to health and safety, for example, confidentiality or home working. There's also other procedures such as grievance procedures and disciplinary procedures, or absence, sickness. So for example, as an employee, if I am unable to attend work because of sickness, I have that obligation to phone my employer and tell them. However, if you're a worker, you don't have to do that. And the key point really in this is, where does the economic risk lie? So as an employee, your company, your employer will have insurance. So for example, take the example of a gas engineer. So a gas engineer, if they work on their own back and they go into someone's house and they cause a gas leak, that liability is on them. They can be sued personally for that gas leak, and that will have to come out of their own insurance. So as a self-employed person, one of the criteria is that you do have your own liability insurance. However, if you're a gas engineer who works for British Gas, then there's this whole concept of vicarious liability, where the employer is liable for the actions of their employees. So that's the key difference, is where does that risk and that liability lie? If it's with the employee or the worker, should I say, then that's indicative that you're a worker. Whereas if the liability lies with the company, then that's more indicative of an employment relationship.
And I think all of those points, they kind of come back to the sort of responsibility point, in that with that risk, if you're taking it all on yourself, then that's the sort of reward, if you like, for paying avoiding the tax payment, I suppose. Whereas if you're an employee, although your wages are less and you get taxed before you're paid, obviously your employer is bearing the responsibility for all of that, and likewise the employer is having to to take the risk and sort of have your back in that regard. So that's the sort of basis for the trade-off and why the current situation has got to where we are. So looking at working for others, that's another factor. I mean, if you are genuinely self-employed, then you can choose who you're doing work for, and you may have a number of clients on the go at one time, and you will be able to juggle those yourself and determine how much of your day is spent working for client A and how much is working for client B. And there's no sort of, there's less loyalty, I suppose, and you can even go as far as to work for competitors, because at the end of the day, you're just providing a service, and it's up to the client that you're providing it to make sure that their service is delivered in the best way possible. And this sort of feeds onto how you're paid as well, because obviously if you're only paid by one employer, one client, that looks an awful lot like a employment relationship. And the same with the tax and NI, which obviously is essentially what we're talking about. But because these two tests do sort of overlap, in that worker status determines whether you need to pay tax and national insurance. But conversely, when you're in a tribunal claim, the judges will look at who's paying tax and national insurance to determine whether there's an employment relationship there as well. So they kind of overlap. And then again, we've got this pay for holiday and sickness and any pension schemes. And it's all about basically the benefits you get. And the more benefits you get from the client, the more likely it is to look like an employment relationship.
So the next point to consider is personal service. And just to demonstrate these questions, we're going to use the example of a bricklayer. So if you have a bricklayer who comes to your house, that's a worker, the questions you should be considering about looking at a worker status, are they able to delegate? So if that bricklayer says, I'm really sorry, I can't make it today, are they able to delegate to someone else? Say, oh, well, I know another bricklayer who can come do your work for you today. If they can do that, then that's indicative of a worker status. However, to compare, I couldn't say, oh, well, I'm sorry, I can't come into work today, but my next door neighbour can come and do my job for me. So that's the difference. You can delegate and sort of subcontract to substitute to work in your absence as a worker, but you can't do that as an employee. Another thing to consider is, are you able to rely on your own assistant or helper? So if you're, say, use the example of a bricklayer again, you might have an apprentice that does that work alongside you. Now, the key point here is actually who pays that assistant or that substitute. It's not going to be the client, except in one situation where Alana is going to describe to you. It's actually going to be you. So from that invoice that you get from your client, you're going to split that between yourself and your apprentice, whereas that wouldn't really work in the same way in an employment situation.
Yeah, so as Molly said, the only real sort of exception for that, I suppose, is, so generally if somebody is substituting you or providing work for you as the initial worker, you would expect to be responsible for paying them if you are a genuine self-employed worker. The exception would be, I suppose, if you are an employee but you are substituted with a temp, then obviously the employer would be paying their salary. It wouldn't be right for you to be paying them. A classic example, I suppose, would be if you went on maternity leave, that employee obviously wouldn't be responsible for paying their substitute, even if it's only a temporary arrangement. That would then fall onto the employer. So yeah, looking at mutuality of obligations, for a long time, this was the key test. I think to most people, this is how we see an employment relationship, in that basically a contract is formed where the employee expects to be able to turn up to their job and be provided with work to do, and likewise the employer expects that employee to turn up and do the work that they're given. If you're genuinely a self-employed worker and somebody offers you a job or a task, I suppose, you can choose whether to accept that or to reject it, because at the end of the day you're in control of your work. And likewise, there's no obligation for the employer to provide you with that work. They will simply approach you as and when they need you. And again, that sort of feeds into how much the business relies on you constantly being there. How integral is your role to the business? If you're not around for a period of time, will somebody else pick up your work, and they could perhaps send that out to another worker or another contractor, or it can be done by somebody else. Or if you if you were absent from the workplace and actually the whole place would crash without you, you're probably a fairly key employee. And even if you are a team member, your absence is going to have an impact on the rest of your team. So it's seeing your own position in the role and how you impact the work and the work that gets done, and how much they rely on you, basically. And then the same thing with this mutuality of obligations. In the same way that you start the relationship with the intention that one party will provide work and the other party will do the work, there's also a presumption that contract will continue so long as the parties intend. But if there were a breach in an employment relationship, you could terminate. So whether it's a breach that comes about by a redundancy or disciplinary proceedings or anything like that, the employer has the right to simply terminate it. Now, in a worker situation, the only right they're going to have to enter that contract is if there's been a real serious breach. And so that's the sort of slight difference. There's other reasons available to an employer which are sort of less contentious, such as redundancies and restructures and things like that.
And then the final little point on that is the question of tools and branding. So one point to consider is who provides your tools. So if you're a worker, you're more likely to have your own vans that you're leasing and your own tools that you're using. Whereas if you're employed, for example, when we go into the office, the computers and the telephones are provided by the company. And that kind of leads on to the second point is, does your equipment have your branding or the firm's branding? So, as working for Parker Bullen, all my advertising and marketing, as it were, is all using the Parker Bullen marketing. Whereas if I was, for example, a consultant solicitor, I might market myself as just Molly Dilling, trainee solicitor, without linking to Parker Bullen. So that is the difference when you talk about tools and branding. And also, who is responsible for your training costs? When we're employees, I guess it's kind of back onto the payoff point that we will do training courses that are paid for by the firm, for example. Whereas if you're self-employed or you're a worker and you need to get these qualifications, then you're going to more likely to have to fund those yourself than if you were acting as an employee.
So the key thing that most people want to know is what are the implications when going through that test. And as we said at the start, it's now transferring so that the business, the client, needs to determine whether they are being a worker or whether they are relying on an employee, and they will use the 5 tests that we've just ran through. But once you've determined the status of that person, that individual, there will obviously be different implications for each. So if, having gone through that test, you can fairly confidently feel that the individual is definitely a worker, and they tick all the boxes that we've already gone through that say that they really are independent in a sort of true sense of the word, then that means that you are operating as a proper business, and HMRC see you as self-employed, and therefore you can continue to pay yourself in the same way and nothing really needs change. But obviously it becomes more of a problem if you go through that test and you determine that actually the individual is really an employee, they're just calling themselves a worker. So if they're behaving like an employee and but for the intermediary company that they may bill through, or any other service that they might, like Molly said, a limited company or something like that, but for that intermediary they would be an employee, then they will need to start paying income tax and national insurance contributions. And likewise, the employer will need to be processing PAYE, and the client, that employer client, will have to match your national insurance contribution. So ultimately, you'll both be liable for the tax, and the end user client can be subject to sanctions for failure to comply. So, obviously, those consequences are fairly serious.
So we're now going to talk about some key tips for employers who are affected by IR35, particularly the changes which are coming forth, as we said, in next April. So the first top tip would be to identify those workers supplying services through an intermediary. So whether you are a business that you contract out, where you contract out some of your services, are you paying the invoices to that individual directly, or are you paying them to a limited company? Secondly, determine whether IR35 applies to any contracts that extend beyond April, because although you might not be liable at the moment, and with those contracts, you may find that once the rules change, you will become liable after April. So you should consider the impact on those contracts that are continuing. And thirdly, talk to your workers about whether IR35 affects their role. So it might not apply to every worker, and it's probably only going to be the case where you contract out your services. But with all employment issues, it's really important that you communicate not only with your employees, but every sort of member of your business, as it were, whether they are a contractor or a subcontractor or an employee. And then also put processes in place to determine if IR35 applies to future roles. So one of the things we recommend is that HMRC have a worker tax status tool, which is not completely conclusive, but it does give a good indication of people's tax status if you're unsure as to how you can do this. And finally, we would recommend that you identify an officer to determine the IR35 status and how payments will be made. So as we've talked about, if you don't comply with the IR35 provision, this could have significant consequences from your company and potential sanctions from HMRC. So it's something that you should be taking really seriously. So if you have a designated person to be able to deal with it, it makes things a lot easier and protects you and your company. So thank you very much for listening. If you have any questions, we'd love to take them.
We should say it is a fairly complex subject, and obviously our focus today has been on determining whether you are in fact a worker or an employee, but obviously those tests are quite complex, and there's, as I said, decades of case law to try and determine those factors. So it may be that you do need to take further sort of advice on the situation, and as I say, the implications themselves, they probably need a little bit more explanation, but trying to keep to the time limit as always.
Thank you, Molly and Alana, and thank you to all of you for joining. We do hope that you found it useful and informative. If you do have any questions, please put them in the Q&A box at the bottom of the screen. In the meantime, we do have a couple of questions that have come in, so thank you for those. So the first question is from Alan. So Alan has asked, what type of business will be subject to the IR35 change?
Okay, thank you very much for attending, Alan, and thank you very much for your question. So the key thing is that at the moment, the IR35 rules, so that the change, which means that the company or the end client, as it's called, the terminology is used, that rule at the moment, that they have to determine the worker status applies to, at the moment, just public companies. So from April, it's going to now apply to private companies. But the key point here is it's not going to apply to all private companies. It's only going to apply to private limited companies who are defined as medium or large businesses. So without going into too much of the legislation, this is governed by the Companies Act. So the three key points are a small business, to see whether you apply under that exemption. Is a small business is defined as a company which has a turnover of no more than 10.2 million, an annual turnover of no more than 10.2 million, has a balance sheet total of no more than 5.1 million, and has no more than 50 employees. So if you come under two or three of those categories, then you can qualify for the small business exemption, which means that these IR35 rules won't apply to you when they change in April. I hope that answers your question.
Thank you, Molly. So we now have another question. This question is from Sue. And Sue asks, what if my boss can tell me where and when to do the work, but they do not actually supervise what I'm doing?
I'll take this one, Molly. So this is a fairly complex subject. It basically comes down to your own competence and the specific skills that are required. So usually when we're talking about control, it's common for a manager to simply be more experienced at the work that the employee is doing. So it's very easy for them to supervise it, very easy for them to tell them how to do the task and tackle the task. in a sort of more traditional manner. But obviously, there are a number of jobs which are really highly skilled, and you will have, I mean, the classic case law example is with a pilot. So if you've got a pilot, obviously that's quite a skilled job, and it doesn't necessarily mean that the manager or the employer will know how to fly a plane, but they can tell the pilot how he should be doing his job, and you know, when they should be working, and you know, which flights they should be taking. But ultimately, he's not going to be telling him how to fly the plane, because that would just be ridiculous. So that's the sort of logic behind that. So generally, it's more as you can kind of just take it on a case-by-case basis, that if the degree of control is appropriate for the situation, then it probably will be an employment status. So I hope that helps.
And we have another question that's just come in. So this question is, will IR35 apply to sole traders who are employers as well as limited companies?
Thank you for that question. So it's quite complex, but the simple answer is no. IR35 doesn't affect sole traders. It only applies to incorporated businesses, so such as your limited companies, whether they're public or private limited companies, and a sole trader can't be caught by IR35, but you must still be aware of employment status, and you know the importance of still determining it. But to answer the question simply, no, IR35 doesn't apply to sole traders. But thank you for your question. If you wanted to know more about that, we maybe talk over email, because it is quite detailed and quite complicated.
Okay, so we don't have any more questions that have come in. If you do think of any questions after this webinar, then please do contact either Molly or Alana, and they'd be more than happy to help. So that wraps up today's webinar. Thank you to Molly and Alana for presenting. Thank you for all of you for attending. We hope you found it useful. There will be a link sent to you after this webinar, and also a summary handout. And if you do have any questions or queries about anything that was discussed, or you'd like any more tailored advice, then please do get in touch. We'd be more than happy to help you. Thank you.
Thank you.